Okay, I'll just try and remember where I was with Ms. Carter. I think I was asking whether you had distinguished between the sources of potential nuisance on one hand, dust and odour, and on the other hand, noise, and what evidence you were relying on for those respective potential effects to give your planning opinion on compatibility with the objectives in the higher order documents about port operations and compatibility. And can you just remind me of your answer there? Because I think it just got lost in the transmission break.
I was first of all saying that one day it could be dust at the port, and another day, and this is from Mr. Dingle's evidence, that one day it could be dust that's the issue, another day it could be odour, and another day it could be noise. But noise does generally feature as a bigger problem in ports. But having said that, Mr. Dingle this morning told us that they had moved one of their PKE storage areas solely because of complaints from residents on the odour. So what I'm saying is that all those potential effects can occur at the port in different amounts and different days depending on what's happening at the port. But I do agree that noise can be a bigger issue over a period of time, but certainly dust and odour do feature as issues that the port has to deal with in terms of complaints from residents.
Thank you for that answer. And you would have heard my questions to Mr. Dingle on this, and Ms. Simpson referenced it. That was the PRC annual monitoring report in relation to dust and odour matters for 2020-21 period. What weight, in your view, should the panel be placing on that report in terms of odour and dust nuisance effects, in your view?
Oh, in terms of the report saying that it had been adequately dealt with, unfortunately, it doesn't fall outside of its permitted activity conditions. Is that what you were?
Yes, I am referring to that.
So, I mean, the port, in my experience with working with Port Taranaki, they do try to be a very good neighbour, and they do try to respond to complaints, and they do try to keep their emissions as low as possible. So I think that it's probably as much a reflection of Port Taranaki's attempts to be careful and not upset its neighbours.
Yeah.
The report was favourable.
Yeah. Ms. Carter, the question was, what weight, in your view, should the panel place on that report?
Well, I think that it speaks for itself. You give weight to the fact that the port comes out with a reasonably good report on those issues. It doesn't mean to say that going forward that there's not additional complaints from this proposed new apartment block or from residents in it. It doesn't speak to the future. It only speaks to the way the port is currently managing its activities, presumably to the best of its ability. So it is put weight on it for 21-22 period.
Thank you. And similarly, and I asked Mr. Dingle this also, it didn't appear, as far as he was aware, that there was a similar report from the District Council in relation to noise compliance. Have you had any opportunity to research that, or is that your view also?
No, but I'm quite happy to source the most recent noise reports from the council and have a look at those. I haven't seen any noise complaints reports myself.
Okay, probably can't take that any further. Then that's fine. But Ms. Carter, my final question is derived from a comment that Mr. Slyfield made today regarding the position of Mr. Fitzgerald in relation to the suitability or otherwise of new residential development in the area between the ICB and the OCB. And explaining Mr. Fitzgerald's position, Mr. Slyfield said that what Mr. Fitzgerald was saying is that that his understanding of the district plan provisions which permit residential subject to attenuation in that area, Mr. Fitzgerald was saying that he was really talking about infill within a residential area, as opposed to a situation that he saw in front of us, which was a new, let's call it brownfield residential development, where residential was the new kid in town on that site, and there would be quite a large amount of it, somewhere, I don't know, 90 units, of which some will be commercial and some would be residential. So that distinction that Mr. Slyfield outlined on behalf of Mr. Fitzgerald, I wonder, does that have any purchase in the district plan, as far as you're aware? That was Mr. Fitzgerald's view in applying the standard, the New Zealand Port Standard. Does it have any similar purchase within the district plan rules as they control residential between the inner and outer control boundaries?
So the district plan, I'm not sure if I quite understand your question in terms of, I understand it in terms of the Port Noise standard, but the district plan doesn't necessarily provide, apart from the objectives and policies, doesn't provide a framework for sort of plan changes or rezoning as such. So I'm not quite sure in terms of the process.
Yeah. Let me rephrase the question. Does the district plan, in providing for residential between the inner and the outer contours, differentiate between infill residential development and new brownfield residential development?
So if I understand you right, and if I understand Mr. Fitzgerald right, he's talking about a rezoning. So in terms of something that was previously not sort of industrial, like you said, in terms of brownfield going to residential, the residential zone provisions allow for infill in the district plan. Are you suggesting looking at whether the district plan looks at industrial and allows for multi-unit development within the industrial zone? Is that the focus of your question?
Sort of.
So
it's really a comparative question between the situation that Mr. Fitzgerald described in the standard, where he differentiated between infill and brownfield, and what the district plan provides for, say, in a mixed-use zone type scenario.
So in terms of permitted activity, there's my understanding is that the district plan doesn't provide for permitted activity residential in the mixed-use zone in any of its mixed-use zones currently in the plan. So at best, it's restricted discretionary near the CBD, the mixed-use zone in the CBD, but every other mixed-use zone. And I think that's expressed in the table 5 that Mr. Resney provided in his addendum, where it shows that permitted residential activity is not provided for in mixed-use zone.
Okay, so what I'm getting from that, Ms. Carter, is that... sorry, carry on.
So and concluding from that rephrasing of your question, the district plan does distinguish between permitted activity residential,
yes,
between infill in a residential area, and if it was to become, say, mixed use, it would be no longer permitted, whether it's within the OCB or ICB. So if it's between the OCB and the ICB, then in the mixed use zone, it still require resource consent and it wouldn't be permitted.
Yes, and that's regardless of whether it's infill or new residential development.
Yes.
Okay. Thank you. That's useful. So apologies if the question wasn't clear the first time. Look, that's all from me. Thank you, Ms. Carter.
Yes, I've just got 2 follow-up questions, or 2 questions. I do want to return to this issue about odour and your disagreement with Ms. Simpson. I've been reflecting on your answer, and what Ross has told us today, and there's evidence that there's been numerous complaints regarding noise, light, spill, dust and odour, but and each time Port Taranaki has been complying with our consent conditions and other regulatory obligations. One of the obligations is to not cause effectual odour across the boundary of your land. Is that as you see the WEA standards regarding the discharge of odour?
Yes, it does, but because it uses that word, which I find quite subjective, the objectionable, if the boundary is a residential boundary, so even though the rule doesn't say on a residential boundary, the perception of what's objectionable will be different in my view if it's a residential receiver than say if it's an industrial receiver.
That's not what I asked you again. So have you looked at the regional plan rules regarding odour discharges and what's permitted and what you might need a consent for? So does that differentiate between residential neighbours?
No, it's objectionable at the boundary.
Okay, so that's test.
Yeah.
So we've got evidence from Mr. Dingle that at all times, it's been a complaint on these matters, you've been totally compliant, the Port hasn't been having objectionable odour. So that's the starting position, isn't it? That's the obligation of the Port on this land.
Mr. Dingle also said that because of complaints about PKE building, the odour from that they shifted.
Yes, but because they need to, because they're causing objectionable odour beyond the boundary of their site. So that's from other residences that are some of them are closer to this development. So the obligation is on the Port to maintain its effects within the boundary of its land. Yes. Okay. So on that basis, you still stand by your in Ms. Simpson saying, well, there's all these mitigations that if something does creep across, people living there are going to go okay, but if odour creeps across, it's not legal. But do you still stand by that statement at the bottom of your paragraph 18 where you disagree with the expert Ms. Simpson?
I think we possibly at cross purposes because of the way I've worded that. Yeah. Just go back to Miss Simpson's three points, if you don't mind, and remind myself of those.
Just I've got those in front of me.
Well, what I'm saying here is that limitations on titles, from my point of view, aren't going to be helpful in mitigating the effects of noise. I mean, of odour. So
But there should be any odour because the Port has to comply with the odour it's found. And there's mitigation that if something does happen that not expected, these mitigation measures she's saying, this is the way I've read it, would sort of
yeah, I see what you're saying. But
so look, I think just to move on, do you still stand by your last sentence in the paragraph 18 where you disagree with the expert evidence of Simpson?
I think for the ones doubt, I'll cross it out.
Thank you. The second question I have is about the reasonableness test of the reasonable future for the Port activities that come from the standard. I think you were here when Mr. Fitzgerald was being asked about that. So as a planner looking at a standard like that and thinking about this is trying to envisage a good district plan outcome, thinking about a reasonable future. Do you think it was reasonable for those noise sources to be placed on the Port's land, oh, sorry, Seaport's land, and we've heard from Slyfield, he says, Mr. Fitzgerald was saying, well, he had to do that because that was port zone, so, but if it wasn't port zone, that wouldn't be reasonable, would it? So,
No, and that's one of the reasons why we suggested that you look at the zoning first, because if the future is a port zone, then the contours will have to reflect that that land could be used for port activities. And so I think that's where we were attempting to, I mean, it could have been more than just, in fact, it's very conservative what Mr. Fitzgerald modelled on the SLC site, on the assumption that it's a port zone and the port would need to have reasonable noise allowance for that site. So I think that going forward, if it's port zone, well then Mr. Fitzgerald's suggestions were conservative. It could have been noisier. There could have been more activities on that site than what he modelled.
yes.
But if it's not port zone, then yes, you take them up.
I asked Mr. Fitzgerald this question, and you know, that reasonable test, should that, and, you know, for us as decision makers, take into account that it's not port zone, it's not port owned, current owners, you know, I'm asking your opinion on this. Current owners are saying that they're not going to use it for any of those sort of activities. Planning purposes going forward, does that make a difference?
No, in my view, it doesn't, because, for example, if this rezoning is not successful and it becomes port zone, then there's a possibility that these owners will sell it or lease it to the port for an activity that the port can do, in which case it will have port activities on it. So it's all very well to say we're not going to do that, but the economic reality is that if they don't get the rezoning, then it will be used for port activities or similar industrial activities that will emit noise. So, and I think that's the what's the word, the issue that the challenge that we have here is that you wouldn't, as an owner of land, keep it for 15 years doing nothing. It wouldn't be derelict for 15 years. You would put it to good use, and that good use might be leasing it to the port or selling it to another buyer who does want to develop it for industrial and port activities.
I do have one last question. This is from Mr. Dingle. I forgot to ask it before, and this relates to the matter we're talking about. Is that okay? Because Mr. Dingle, that property, the port did have an opportunity to purchase this land, didn't it?
Yes, that was before my time, and I
Yes.
do have some understanding of that, but probably not the detail, but
Yes.
I can try and answer.
So the port could have protected itself against reverse sensitivity on the site by buying the land, and and that was a commercial decision you made, or the port made at the time.
That would be correct.
Yes. So that's another technique the port had available to protect themselves against reverse sensitivity activities, and you did not. You decided for commercial reasons not to take that opportunity up.
Yes, so my understanding is that the site was considered problematic, therefore didn't take that opportunity up.
Problematic because
There was a oil well on there, and then when you think about port activities, particularly our port, for our port, you know, log storage, bulk storage, and when you get inside those buildings, there's lots of pillars which make it difficult to manoeuvre trucks through there. So on that basis, you know, equally it could have been picked up by someone else and utilised for port activity.
and stores.
Yep, stores,
Did
marine
the
maintenance type
port
things.
consider buying it and knocking it down and doing all those things that would weigh in on the commercial
Look, I
aspects?
don't know that level of detail, I'm sorry.
You've been here since 2000
June 2019.
so it was purchased before your time, so you can't really answer us on you've given us what you
So
understand.
the high level is that the port considered the property problematic, and I'll describe the reasons why that was.
Okay, Philip, I think that's everything we have.
Mr. Chair, I have one question of clarification,
Right.
and it's just following up. I don't want to go back over. I think it's been a very thorough conversation with Ms. Carter in relation to odour and dust.
Yeah.
She said, for the avoidance of doubt, take the last sentence of paragraph 18 out. In my mind, that leaves a question at large, which is she accepting Ms. Simpson's view about the effectiveness of no complaints covenants? I wonder if it's going to assist you to have her confirm what her view on that is.
Let's just do that. There were 3 mitigation measures, but yes.
Yeah, so I think I did mention that in my reply before, that I wasn't convinced that the no complaints covenants were an effective means of dealing with dust and odour. Mainly because
In the
it does stop
context,
people
yeah,
complaining.
in the context that the port's duty is to avoid objectionable odour at its boundary. Thank you. I think that clarification is fine. We know your opinion on that. Look, let's have a discussion about the rest of the day. Firstly, are you on the 5:30?
The 5:40, we weren't expecting the hearing to stop for us. I mean, the SLT and
Yes.
CAP are here, so
Yes.
they can listen to the rest of it. So
Yeah, so
if
that
you wanted to carry on, please do.
Yeah, but I just have to say that we had other people on a 5:40 here and they left at 4:30. So
That's fine too.
Yeah. So I just wanted to organise the self. So and the other thing is our staff team were cut off short for the Blue Haven hearing because we ran out of time as well. I certainly don't want to do that again for the right of reply. So, Hamish, how long do you think you need for the verbal right of reply with your experts?
Well, we had a lot of information today and previously, so I'm not going to be in this position and Sarah and Nigel. I don't think we'll be in a position today to give you a verbal response and okay. Shortly.
Okay, so would that be tomorrow? Because we're finishing the hearing.
Lloyd,
Right,
Lloyd just joined.
Yeah, Mr. Lloyd.
yes, okay, well, let's do that. So Sarah, you are up. If you can, and if Julie can come on, whatever order you'd like.
You don't want to know.
No, it's
Yeah.
That's right.
Given brief, Julia, responding there. Yes.
Liaising with Julie. Julie's having some trouble with her camera. Julie is there. Oh, tēnā tātou. O Sarah mako wharima hihi tōku ingoa. Te tautai au ki te whakaisanga o Te Atiawa Trust no Taranaki au. So kia ora. The beginning of the hearing, I was in the COVID state as well. So I was actually horizontal on my couch. So every now and again I'd hear my name mentioned. So sorry if hope I can cover off most of those things that were discussed. So yeah, just a little bit of a pronunciation lesson. So I'm Sarah Mako. So actually my full surname is Mako Wharemahi here. So we've had this kōrero before. So I'm more than happy for you to just call me Sarah. Or you can call me by my full name, Sarah Mako Wharemahi. So I've got Julie online as well. So Julie's just having issues with her camera. You can hear us?
Yes. Can you hear
Is
me?
it okay if we
Can you hear me
started?
okay?
We start with Julie?
Yes. Can you hear us, Julie?
Yes, kia ora tātou. Sorry about all that noise
Kia ora.
before. I just accidentally hit the mute button and had a coughing fit. Just my good. So, yeah, hope you're all well.
Starting with you.
Look, I'm just,
Yeah, Paul.
yeah, called Julie Hiri Tapuingoa, called Ngāti Te Whiti Hapu Chair. Welcome the commissioners back into Ngā Motu, and though you're probably ready to fly out again. Hope the visit's been enjoyable. And yeah, look, I'm sure everyone's probably read the evidence, and I'm quite prepared just to take questions if you're happy with that. It's up to you, Mr. Chair.
Just give us the highlights in your words about your view of the Seaport proposal and the relationship you have with the Seaport and the port, and yeah, so just a few highlights to get us focused, Julie.
With Seaport, for Ngāti Te Whiti, it was an opportunity to re-establish ourselves on that whenua once again, to be able to connect to that whenua, to revitalise those stories of our tupuna. Yeah, it was pretty exciting stuff. So we've been in touch with our Seaport around with the development and of course the rezoning, and we're pretty excited actually and looking forward to end results. I guess everything that we'd like to see done in there would be, like we said, like some sort of co-design if possible. We have a few whānau that are talented, very talented, and they are professional artists. They work alongside the people like Boone at the moment. We've even got one with Aaron and Mahoney, one working on the Tūparea Kino hub. So the experience is out there. They know what they're looking for, and they'll concentrate more on Taranaki and what is Ngāti Te Whiti. So to have that that visual and that, you know, that visible reflecting in our whenua back in this project would be amazing for our people. Throughout the whole, if there's a marina down there, I guess we'd like to see our designers working through there as well with a lot of our stories. We'd hate to see, because our landscapes change so much that we're just about disappearing. However, with our applicants that we've had in the last couple of years, we're able to bring that footprint back of Ngāti Te Whiti and Te Atiawa back into the rohe, which is a good thing, but we can't just stop, we must keep going. Yeah, so just looking forward to the future, I guess. Also looking after that environment, we have to protect, as Kaitiakitanga, we must protect that environment with the port and with any other development in that area. So,
Yes, thanks for that. Thanks for that summary, Julie. Really appreciate that, and that does summarise the key points I've read in your evidence.
Oh, no.
You would have seen the evidence from Catherine about tying together in the plan rules this co-design process as a starting point for going forward with developing the precinct plan. And then that provisions in the plan that I think Catherine's trying to lock in, that if that doesn't happen, we'd have to go through a consent process. So this is a mechanism that's been proposed to us to ensure that that co-design does happen. And I think you're supportive of that requirement in the plan. Is that correct?
Kia ora, yes, it is correct. In the beginning of the relationship with Seaport, we had a few other things, you know, like opportunities for the hapu, and one was, a lot of it was that design through that development, but also maybe looking at things like ownership, office space, and everything else, not just artwork. But yeah, I agree with what you've just said there.
Yes. Julie, in the hypothetical that the port zoning does stay and the only feature of the site is to keep the buildings and do some sort of storage inside them, or demolish the buildings and do some other port activities, and there's a whole range of things that could happen on that site. How would the hapu feel about that?
Ooh. The ultimate would be to have that connection with the whenua. So with their relationship with the port, I would expect they would hopefully let us on board there as well, if that's the case. But it would be sad to see, it would be nice to see Motoroa in that area spruced up a bit, you know. I'd like to probably see the development go ahead. However, what will be, will be.
Okay, thank you. David, did you have any other questions for Julie?
No further questions from me, Stephen.
Okay, thank you, Julie. We might see you tomorrow with some other witnesses. If we don't, I'd just like to have a big kia ora to you, and thank you for your participation as we've worked our way through many issues over the last year.
No, thank you. It's been a good experience, and one the hapu appreciate much. Thank you very much.
Okay.
Thank you to everybody else, especially to Miss Sarah Muckle, for all that hard work you've done, Sarah. Kia ora.
Right, thank you, Julie. That's everything we have for you today.
So I'm not as diligent as the other committers. I haven't prepared, I guess, a summary of my evidence. So I sort of just summarise the key points for you. So just three things that I wanted to cover off today were those points are the sites and areas of significance to Māori and the relationship of Ngāti Te Whiti with their cultural landscape. Secondly, the master planning process, and that flows into the precinct provisions that have been proposed by Seaport. So in relation to SASM, I have reflected on kōrero I've obviously had through these hearings, but particularly the presentation that I had during hearing, I couldn't remember if it was hearings 13 or 14, but it was actually with Commissioner McMahon from memory. So specifically, we spoke about the site-specific responses to sites and areas of significance to Māori. And during that hearing, and I still maintain this view, that I felt that site-specific responses would genuinely be the best response, but given where we're at in the proposed district plan process, that the SASM chapter and the rules, and here noting, I guess, that I've still got some concerns about where we got to with the rules and through the right of reply, that those rules provide a broad response to protecting SASM from inappropriate development and recognising and providing for the relationship of tangata whenua. So I've presented a large amount of evidence to the panel regarding a lot of evidence as well regarding the heavy lifting that the overlays chapters are going to have to do. So I've reflected here, I've briefly reviewed the evidence of Ms. Carter and Ms. Hooper for this hearing in particular, and in relation to the SASM, notably Ōtaka Pā, which the the Seaport site and the Port Taranaki buildings are located. So did you mention you're going to Port Taranaki tomorrow, Friday? So actually, I really love this part of the building. So when you, I'm not sure if you'll go into the port building, but at the entrance is actually an arrangement of hangi stones that were uncovered during the build of the Port Taranaki building. And so one of our kui and kaumatua, so Julie Johns, so Julie Julie Johns was there to tow Toko Julie Healing at Hearing 5.
Yes.
And so Julie Johns and Auntie Andress also supported, was a Waita Totoko at that time. So Julie Johns, sorry, getting back to that point, Julie Johns did arrange those hangi stones that are in the port building entrance. So anyway, so back to that. So Ms. Carter is of the opinion that the port zoning or an industrial zoning will preserve the SASM and the relationship of Ngāti Te Whiti with the SASM. Ms. Hooper is of the opinion that the active relationship of Ngāti Te Whiti will not be able to occur if an industrial zoning is implemented on that land. I've just noted here, I'm unsure if Ngāti Te Whiti have informed both of those statements. So whilst I do not necessarily disagree with Ms. Hooper, and my opinion there is based on the evidence and advice of Ngāti Te Whiti to both this hearing and to other hearings, that the comments by Ms. Carter highlight the shortcomings of the port zone provisions, particularly in relation to the relationship of Ngāti Te Whiti with the ancestral lands and the protection of SASM from inappropriate development. So I don't intend to relitigate everything that, or all of my evidence that I've presented, particularly to hearings 5, 14, 20, and 21, but remain of the opinion that the port zone provisions are deficient in regard to this matter. And just reflecting on that as well, is that I'm aware that Port Taranaki are potentially seeking an existing use certificate for maintenance work in proximity to SASM. So in the context of the port zone, I guess I've just become more and more concerned that relying on that SASM mechanism, that it potentially isn't not the most effective in protecting SASM and recognising and providing for the relationship of Ngāti Te Whiti in that area. So with regard to the master planning process, I consider that the intent of that is great. And I've set that out in my evidence as well. So based on the advice of Ngāti Te Whiti that I've been so less than lucky to hear, I consider that the master planning process will encapsulate much of what Ngāti Te Whiti and Seaport Land Company have been engaging on since 2017, as well as the evidence of Ngāti Te Whiti and other tangata whenua submitters to the proposed district plan. As set out in my evidence, I am of the opinion that there must be a clear trigger for this master planning process. At this point, you'll note from Ms. Hooper's supplementary evidence as well that that indicated that I was happy with the provisions that Catherine had proposed in her evidence. And I guess just to reiterate here, whilst I thought the intent of the provision, specifically Rule 19, was great, the intent of it, I had raised concerns about its lawfulness, and I think that's based on relying on documents that don't exist yet. And I guess you raised questions about that yesterday. Sorry, Commissioner Daish, and also Dennis, Ms. Carter, has just has spoken to that as well this afternoon. So in relation to the provisions proposed by Seaport, we've also obviously received the expert evidence of the economists. So I had obviously raised concerns about that in my evidence, and that was purely based on my participation in the Blue Haven conferencing as well. So I guess we have that now, which is useful. And I guess just in terms of the provisions as well, thinking about, well, reflecting on the Seaport site is on Otakapa. And so essentially anything that happens on that site will require resource consent as a discretionary activity. So I was thinking about that building activities rule, that rule 19 as well, which I've recommended that through my evidence as well, is that potentially there's an opportunity for it to be, and I had recommended it as a controlled activity, but in reflecting on all of the evidence that it may be best if it was a discretionary activity, and I know that this site is obviously very different to the Blue Haven site. There are some similarities, but that potentially a discretionary activity for building activities is more appropriate, and that policy direction around the master planning process can be better relied on. And that is about my summary. Finish bluntly there.
Thank you. Sarah, do you think that you'd like to, we've got some new evidence that we've got the updated provisions for the precinct, Catherine, and we've got the new evidence from Ellen and Mr. Heath. Is there anything else you'd like to give us, or Dennis is going to come back to us by the end of the week, just to sort of have any thoughts and provide anything additional on those two aspects?
Provide a supplementary statement. I think mine will be relatively brief.
Great, but also just picking up, you're reading off your notepad in sort of the sum. You've written down the summary you've just given us.
Yeah.
Now?
Yes, then I can.
So just put that together as an overall summary. But I do have a question about Otakapa and the fact that that whole Seaport site you've told me is historically part of the PAR, and that's is that why Ngāti Te Whiti is so interested in doing this co-design with Seaport if they get zoning and go forward with the project, so that the respect and the design, respect of the PAR in the past and the design can reflect that? That's the essence of it?
That's my understanding. Just reflecting here on some of the evidence that Rangi Kapa has given as well, is that it doesn't necessarily need to be, a scheduled site and area of significance to Māori for it to be important to tangata whenua. And that co-design process has been, in what I've experienced recently under the operative district plan, is that there's good outcomes for the whole of the community.
And the scenario where it stays, so the planning, long-term planning perspective for Ngāti Te Whiti and you as a planner, that was a different range of opportunities that Janet set out in her three. Some of those might still need consent, but there's quite a lot of permitted activities there, aren't there?
Yeah.
Are you saying that whatever happens there, you'd have to go through a discretionary activity or because of SASM localities?
Yeah, so under the SASM rules, it would be earthworks and buildings would
Yes.
definitely be discretionary.
So there'd be protection there.
On
terms of-
that,
Of, yeah, so they would have to be considered in any application that was made about culture or effects on the relationship of Ngāti Te Whiti, those 6E matters.
and just reflecting on lots of conversation we've obviously had during the hearings, and that the SASM rules are quite narrow in terms of that protection and recognising and providing for that relationship, and that a site-specific response like that provides, for, in my opinion, I can see those greater outcomes of us Ngāti Te Whiti and Te Kotaitanga working on working through a co-design process.
So you're talking about the seaport,
Yes, seaport site.
the seaport proposition. The alternative, if it stayed port zoning, would you still want to see the same designing going on for port-related activities if that was the zoning choice we decided was appropriate or most appropriate?
Yeah, if I can reflect on the experiences that I've had with Port Taranaki and with Ngāti Te Whiti, being a witness to the growth and the development of that relationship between those two, is that I think there would be that expectation now with that Port Taranaki know that they would need to do that now as well.
So look, I think that's everything. Wrap it up, I think. Was there anything else that you wanted to say, or David, did you have any questions?
Thank you, Stephen. No questions for Ms. Markle, but based on Ms. Marco's indication about the potential lawfulness of Rule 19, I just wanted to remind Mr. Wesney that some response on clauses 1, 2, and 3 of Rule 19 would be appreciated. I think we've talked about clauses 1 and 2 previously, but I was also add 3 in terms of the necessity for that clause also. And secondly, just an understanding of how non-compliance with the effect standards and standard 4, they are the retail floor area restrictions. My understanding is that triggers to a restricted discretionary activity. If Mr. Wesney, when he comes to give his reply, could give his view as to the appropriateness of that by reference to similar default activity statuses in other zones where floor areas are not complied with. Just want to make sure that there's some consistency there. So no direct questions to Ms. Markle, but out of Ms. Markle's evidence, some questions to Mr. Wesney.
He's writing furiously, David, so he's got that on the radar. Right. I think all we need to now talk about is the level right of reply. And we do have time programmed tomorrow for the verbal right of reply on hearing 23B. And I'm anticipating that it will be in the morning sometime, but would it be okay to come in after that to do your verbal right of reply on this hearing, Hamish?
Sure, no, that would work for us.
Nigel, you
Either before midday.
for midday. Well, I wonder whether we should just do that first. Why don't we do that first? So we'll hear the 23B evidence from the Taranaki Legal Watch and then from food. And then we'll pick up your verbal right of reply first, and we're going to the verbal right of reply for the 23B authors. Make sure we try and manage the third Sarah in the room's expectations. or requirements. Yeah, okay. Well, thank you, everyone, and certainly finished time to get out to the airport. I'd like to thank everyone's attendance. It's been, I suppose on balance, it's been nearly maybe 300 days, and I think we needed that time. And I'd like to appreciate everyone's participation and advice, and I think you all realise this is going to be quite a taxing decision for David and I to make, but we'll certainly take on board all the evidence and the advice we've got in making the best decision we can. We'll get the first sort of round of that advice through the verbal right reply from the Puri QA team. Thank you.
You don't have to follow it up with it. God, if it's not recorded. Oh, well, Kati Perunga, tēnā tātou katoa, Commissioner Dash, ka piki te ora, e hoa koutou mā kia pai tō pō, me karakia whakakapi, unuhia i te uru tapanui. Kia wātea, kia māma, te ngākau, te tinana, te wairua i te ara takatu. Hoi rā, e rongo whakeiri ake ki runga, kia wātea, ai rā, kua wātea, au pai mārere.
Pai mari. Kia ora, Sarah, tēnā koe.